presidential elections. We further order a fresh election to the office of the President to be held in accordance with the PPA and pursuant to the consequential directions that we make hereunder. End quote. A declaration that the President was not duly elected is made under Section 100, Subsection 3, Paragraph B of the Parliamentary and Presidential Elections Act, while Section 100, Subsection 4 of the Act provides for the holding of a fresh election of the office of the President, which shall be held in accordance with the Act. The court below made a finding of undue retain and undue election of the President. When it came to making the constitutional orders, the court below erroneously nullified the presidential election. In accordance with Section 100, Subsection 3 and Subsection 4 of the Act, the court below should instead have used the language of the statute and simply made an order that the first appearance was not duly elected to the office of President. We therefore find that the first appearance was not duly elected to the office of the President. We find that the order by the court below that fresh elections for the office of President be conducted in accordance with the Parliamentary and Presidential Elections Act to be proper, and we uphold it. We note that in its consequential directions, the court below stated in paragraph 1483C of the judgment, thus, we quote, "The fresh elections herein shall be held within 150 days, including Sundays, Saturdays, and public holidays from the date hereof." End quote. This order or direction took effect on the date it was pronounced, being 3rd February 2020. We observe that in fixing 150 days within which to hold the fresh elections, the court below acted in exercise of its discretion in the circumstances as it saw them. We are aware that electoral matters are urgent matters, and the electoral disputes must be resolved expeditiously. We hold that a long delay in holding fresh elections for the office of President in the event of an undue retain under Section 100 of the Parliamentary and Presidential Act is not justifiable under the law and is not in the interest of democracy and good governance. The law envisages that a by-election or a fresh election shall be conducted in the shortest possible time after the occurrence of the event that necessitates it. Section 63, subsection 2, paragraph B of the Constitution in relation to a vacancy in the seat of a member of the National Assembly provides as follows. We quote, "Any by-election to fill a vacancy that occurs shall be held within 60 days after the seat of the member becomes vacant, or if in the opinion of the Speaker, the circumstances do not admit, then as expeditiously as possible after the expiry of that period." End quote. It is significant that the by-election must be conducted within 60 days, or where necessary, as expeditiously as possible after the expiry of the intervening event. More of particular relevance to this case is Section 85 of the Constitution, which provides that, we quote, "If at any time both the office of the President and first Vice President become vacant, then the Cabinet shall elect from among its members an acting President and an acting first Vice President, who shall hold office for not more than 60 days, or where 4 years of the presidential term have expired for the rest of that presidential term." End quote. The Constitution thus provides for circumstances where both the office of President and First President may become vacant. Those circumstances are not spelled out and are not claused. In the event of there being an acting President and an acting First Vice President, elections for a President must be conducted within 60 days if it is within 4 years of a presidential term. It is for good reason that a period of 60 days within which to conduct by-election or fresh elections is provided for in the Constitution. It is consistent with the principle that electoral disputes must be resolved expeditiously. It is also consistent with the view that preparations for a by-election or a fresh election do not take the same form as preparations for a general election. A declaration of undue election is a result of a challenge. The party that succeeds is entitled to an effective remedy. The right to an effective remedy accrues only to those whose rights are affected. These are voters, the candidates, and their supporters who voted for them, and of course, the electoral system, as we have said earlier in this judgment. In this regard, it is the same voters' roll as was used in the general election that should be used in the by-election or fresh election. From a rights point of view, it is those voters who voted and those contestants who contested in the immediate past general elections whose rights were violated or injured by the impugned conduct of the Commission or by the wrong decisions of the Commission who must be given a second chance to vote. The law does not envisage registration of new voters in a by-election or fresh election because such voters were never wronged in the first place by the impugned decision of the Commission. In our view, in the matter at hand, the fresh election for the office of the President should have been held within 60 days from the date the court below made a declaration of undue return and ordered fresh elections, being 3rd February 2020. We are mindful that the court below exercised discretion in setting 150 days within which to hold fresh elections. We will not overturn that period merely because we would have ordered different. We reluctantly uphold the period of 150 days ordered by the court below, within which the fresh elections for the office of President should be held. We proceed now to give consequential directions and recommendations. It was proper for the court below to make consequential directions and recommendations following the determinations it had made. Indeed, where there are breaches of constitutional provisions and human rights provisions, the court has a duty to provide an effective remedy and enforce the human rights. The court below's reference to sections 41 subsection 3 and section 46 subsection 3 of the Constitution in its endeavor to provide an effective remedy and enforce human rights was appropriate. We hasten to add that section 46 subsection 3 of the Constitution should be read with section 46 subsection 2 of the said Constitution. Section 41 subsection 3 of the Constitution provides for access to justice and legal remedies in the following manner. We quote, every person shall have the right to an effective remedy by a court of law or tribunal for acts violating the rights and freedoms granted to him or her by this Constitution or another law. End quote. And section 46 subsections 2 and 3 of the Constitution provide as follows. We quote, any person who claims that a right or freedom guaranteed by this Constitution has been infringed or threatened shall be entitled A, to make application to a competent court to enforce or protect such a right or freedom, and B, to make application to the Ombudsman or the Human Rights Commission in order to secure such assistance or advice as he or she may reasonably require. 3. Where court referred to in subsection 2A finds that rights or freedoms conferred by this Constitution have been unlawfully denied or violated, you shall have the power to make any orders that are necessary and appropriate to secure the enjoyment of those rights and freedoms, and where a court finds that a threat exists to such rights or freedoms, it shall have the power to make any orders necessary and appropriate to prevent those rights and freedoms from being unlawfully denied or violated. End quote. When a court notes legislative gaps or inadequacies, the court may recommend to the legislature to make appropriate redress. It is perfectly proper for a court to make a strong recommendation to the legislature to take legislative action to address a gap or inadequacies in the legislation, provided it remains a recommendation. A court must recognize that the legislature is a deliberative forum and a time-honored principle of checks and balances among the three branches of state ought to be respected. The court below rightly observed that position under Section 80, Subsection 1 of the Constitution, and the significance of certainty in the democratic process brought about by the fixing of the date for general elections under Section 67, Subsection 1 of the Constitution. The court was entitled to hold a view that Parliament needed to take appropriate legislative measures to ensure such certainty is preserved, whilst at the same time ensuring that whoever is elected president of the republic during the fresh elections is allowed to serve a constitutionally prescribed 5-year term. This is a correct view which should give a recommendation to the legislature on the matter. The court went further to suggest an option. It remained open to the legislature to do more than this recommendation on legislative action to ensure orderly fresh elections and better manage future presidential elections. It is important that Parliament fixes the date of the fresh election. By the terms of the order of the court below, that there be a fresh election for the office of president within 150 days, it is a legal requirement that a president must be elected and duly retained and sworn in by the commencement of 151st day from the date of the judgment of the court below. It is further recommended that in view of the 50% plus 1 interpretation of a majority of the electorate in Section 108, Section 2 of the Constitution, the legislature should expeditiously put in place the necessary legislation that will ensure smooth implementation of the constitutional provision. As we have earlier found, we direct that only the parties whose rights were injured by the impugned conduct of the Commission on the 21st of May 2019 should participate in the fresh election. The Commission must use the voters' register that were used in that election. New entrants on the voters' registers must not take part in the election. Further, only presidential candidates who competed in the 21st May 2019 elections are eligible to compete in coming fresh elections. We now deal with the matter of costs. The general principle in litigation is that costs for the event, whether to award costs or not, is a matter in the discretion of the court. This matter is public interest litigation, and the first appellant was entitled to exercise his right of appeal and fight for his space. Although the first appellant is not successful in this appeal to this court, he will not be condemned to pay other parties' costs. He will pay his own costs. With respect to the second appellant, we agree with the court below that the Commission is a duty bearer and not a holder of rights seeking to vindicate legal rights. We have made observations and findings that reflect negatively on the conduct of the Commissioners in handling the general elections of 21st May 2019. We want to observe that the conduct of the Commission in the court proceedings here and below left much to be desired, resulting in loss of also sums through litigation, to say nothing about injury to our democratic processes, as well as general and unquantifiable suffering of the people of this country. The truth of the matter is that all that loss and suffering could have been avoided had the second appellant conducted itself prudently as a duty bearer and assist the court early in the litigation of the matter, rather than take sides. We are reminded of that the Commissioners personally pay costs to the petitioners in this matter here and below. We are, however, content to semi warn that any future wasteful and inappropriate conduct on the part of the commissioners will attract costs to be paid personally by them. In the present matter, we order that the second appellant pays the first and second respondent costs for this litigation here and below. We have checked the quorum in the court below, and we don't understand how so many legal professionals could have presented the parties in these proceedings. We order that both party and party costs and solicitor, lawyer, and own client costs should be taxed by the registrar. My Lord Chief Justice, that should be all for now. Thank you.
Thank you so much. That is the judgment of the court. As I said in the opening remarks, and indeed in the course of the judgment of the court is and remains unanimous. There is a dimension that Justice of Appeal Twaya would want to present. I want to repeat what I said earlier for the avoidance of doubt and misunderstanding, that Justice of Appeal Twaya is not dissenting. He does not disagree with the decision of the court in any respect, but there is an issue that he thought he should offer guidance on, and therefore will allow Justice Twaya to present that aspect of the matter. My Lord.
Thank you, my Lord Chief Justice. Having heard my brothers in respect of the constitutional orders that were given in the case by the court below, more particularly paragraphs A, B, and C, I wish to give a divergent opinion on the position taken by the majority of my brothers. For clarity, I'll reproduce paragraphs A, B, and C of the said consequential directions and the constitutional provision on which they are predicated. They are in paragraph 1483 of the judgment of the court below, and I quote, as the necessary consequence to the determination herein, and having in mind Section 41, subsection 3 of the Constitution, which grants all persons in our jurisdiction the right to an effective remedy by a court of law, as well as Section 46, subsection 3 of the Constitution, which gives the court the powers to make any orders that are necessary and appropriate to secure the enjoyment of rights and freedoms which the court finds to have been violated, we order the following. A, for the avoidance of doubt, the declaration that we have made that the first respondent was not duly elected during the 21st May 2019 presidential election, and therefore that the said election were invalid, it consequentially follows that the status of the presidency, including the status of the office of the Vice President, reflects to what it was prior to the declaration of the presidential results on the 27th of May 2019. As per Section 100, subsection 5 of the PPEA, the declaration herein does not invalidate anything done by the President or Vice President before the declaration of invalidity herein. B, we are also mindful that under Section 80, subsection 1 of the Constitution, a presidential election has to take place concurrently with the general election of members of the National Assembly as prescribed by Section 67, subsection 1 of the Constitution. The Court appreciates the significance of the certainty in our democratic processes, which is brought about by fixing of the date of general elections under Section 67, subsection 1 of the Constitution. In view of this position, we are of the view that it is appropriate that such certainty be preserved. In the circumstances, we hold the view that Parliament should take appropriate legislative measures to ensure that such certainty is preserved, whilst at the same time ensuring that whoever is elected President of the Republic during the fresh election herein is allowed to serve the constitutionally prescribed 5-year term. One of the options the Parliament might consider is to extend the term of the incumbent members of Parliament and shift the election date from May to July in order to ensure the preservation of such concurrency. C. Fresh elections here shall be held within 150 days, including Sundays, Saturdays, and public holidays from the date hereof. From the reading of the above, end of quote. From the reading of the above directive, it is my view that the court below, in fact, found that found that 1. The presidency of the previous general election reversed when the court finds that there is undue election or return of the president under Section 100 of the Parliamentary and Presidential Election Act. 2. That it has jurisdiction to extend the presidency of the previously elected government. And 3. That it has the discretion to determine the time frame for ensuring fresh elections. I am aware, as this court is, that none of the parties raised this on appeal, although it was left open in the arguments and has been subject of several applications on stay and extension of the time of election by the second appellant. This court, under Order 3, Rule 2, subsections, Rule 2, Paragraph 1, determines appeal by way of rehearing. I do not wish to belabor this. However, it is tried that this court's duty is not to retry the case. It will only subject the evidence of the court below to a fresh scrutiny. The court will review the decision of the court below if it finds that there was an error of law, an error of fact, an error of mixed law and fact, and that the court below exercised its discretion wrongly. In my view, considering the issues that have been raised, I find that there was an error of law. Had the court below considered the totality of the circumstances, it would have come to a different conclusion. I will therefore consider 3 major circumstances under the Parliamentary and Presidential Election Act, which provide for election of president other than by general election, namely Section 54, Section 114, and Section 100. To illustrate this point, let me begin with Section 81 of the Constitution. Section 81 of the Constitution provides that, subsection 1, before a person elected to be president or first vice president or appointed to be first vice president or second vice president takes office, that person shall take the following oath, which shall be administered in public by the Chief Justice. Subsection 3, a person elected to be president or appointed to be first vice president or second vice president shall be sworn into office in accordance with subsection 1 within 30 days of being elected or appointed. Subsection 4, the president and first vice president shall hold office until such time as his or her successor is sworn in, close quote. The import of this section is clear. The president or first vice president will assume office only after being sworn in. Further, that the swearing must be administered within 30 days after the Electoral Commission declares the return to the office of the president or first vice president. Upon swearing of president, the previous holder of the office of president and first vice president, even second vice president, if there be one, cease to hold office. The swearing in of the president-elect and the first vice president-elect and the attendance ceremony signifies succession to the office. The president, having been sworn in, would then proceed to appoint ministers and form a cabinet, according to sections 92 and 93 of the Constitution. Section 81 of Section 1 therefore signifies the handing over and taking over of the presidency, the democratic succession of the presidency. The old presidency ceases to exist or in whatever form after that. The scheme for the elected part of the government is provided for in Section 67 of the Constitution. Section 67 subsection 1 of the Constitution provides that, and I quote, The National Assembly shall stand dissolved on the 20th of March on the 5th year after its election. The polling day of the general election for the next Assembly shall be the Tuesday in the third week of May that year, provided that where it is not practicable for the polling to be held on the Tuesday in the third week of May, the polling shall be held on a day within 7 days from that Tuesday appointed by the Electoral Commission. Close quote. Under Section 80, subsection of the Constitution, the President in a general election will be elected concurrently with members of the National Assembly. This constitutional provision is also reflected and provided for in Section 32, subsection 4 of the Parliamentary and Presidential Election Act, which states, subsection 4, and I quote, "Subject to this Act, in a general election, the poll for election of members of the National Assembly may be taken simultaneously with the poll for election of the office of President." Close quote. When the National Assembly is dissolved, the institution of governance that subsists are the President as head of state under Section 49, subsection of the Constitution, and the judiciary. Section 67, subsection 4 provides that the President can reconvene the National Assembly in case of a constitutional crisis or emergency. The reconvened National Assembly will transact the business for which it has been reconvened only. In any case, however, it would stand dissolved on the date of the general election. Clearly, the National Assembly of the previous government does not survive beyond the general election. When the general election has been had, the Electoral Commission will determine the national results in accordance with Section 96, 97, 98, 99 of the Parliamentary and Presidential Elections Act, which this court has referred to in the majority judgment. Members of the National Assembly are required under Section 67, subsection 3 of the Constitution to be called to Parliament within 43 days from the polling day. This, however, happens after members of Parliament have taken oath under Section 52 of the Constitution, which states that every member of Parliament, before taking his or her seat, and every officer of Parliament, before assuming duties of his or her office, shall take oath and subscribe before the Chief Justice in the National Assembly, A, the oath of allegiance in the form prescribed by law, and B, such other oaths for the due performance of their respective officers as may be prescribed by law. Consequently, the President and members of the National Assembly, having been sworn in and taken oath, as the case may be, then we get a new democratically elected government, which was being elected by the people at a general election. I will now go back to sections 54, 114, and 100 of the Parliamentary and the Presidential Elections Act. It is important to state that Section 77 of the Constitution provides for the franchise of the people of Malawi. Section 77, subsection 1 of the Constitution reads as follows: all persons shall be eligible to vote in any general election, by-election, presidential election, local government election, or referendum, subject only to this section. Parliament has so far enacted laws to govern the general election, by-election, local government election, and referendum. Let it be clarified that a presidential election in this case means an election of a president other than by a general election. However, there is no law to govern an election of a president outside the general election, or what has been termed the presidential election. The Parliamentary and Presidential Act in Section 57 provides for a fresh election that in fact is a presidential election. It states, and I quote, where, in subsection D, a candidate for election of the office of President who would otherwise have been entitled to be declared duly elected as President dies after the poll has begun in an election, to the office of President, but before he has been declared duly elected as President, the Commission shall, by notice published in the Gazette, declare that all proceedings relating to the election of the office of President are void, and that proceedings shall immediately commence a fresh election in accordance with this Act. The Commission has the duty to declare the proceedings relating to the election void. Proceedings for a fresh election then begin immediately. The time frame for such an election is therefore provided by the Parliamentary and Presidential Election Act. In such a case, no one is declared duly elected. The proceedings relating to the election are void ab initio. The incumbent president will continue office until a new candidate is returned and the president sworn in the fresh election. However, where the incumbent president, it is the incumbent president who has died while he or she is a candidate, the first vice president will continue in office until a fresh presidential election is determined. Under Section 114 of the Presidential and Parliamentary Act, this is a section that governs appeals to the High Court before the national result is declared. I will refer only to the most relevant parts because we have referred to this earlier. I will refer to subsection 5, which says, at the conclusion of a trial of an election petition, the court shall determine whether the member whose nomination or election is complained of or any other, and what person was duly nominated or elected, or whether the election was void, and shall report the determination to the Commission, upon which report being given, the determination is final. Subsection 7 is, notwithstanding subsection 6, the High Court shall have power, subsequent to the holding of an election, to declare void the election if, upon hearing the petition referred to in subsection 1, the High Court is satisfied that there are good and sufficient grounds for declaring void the election. This election applies to all appeals from the Commission's decision in respect of complaints placed before it, including those brought at the beginning of the determination of the national results under Section 97 of the Parliamentary and Presidential Elections Act. The gist of the section is that the court has power to declare the election void. The election so declared is void ab initio. No result will be declared thereon. If the complaint relates to the election of the president, the declaration under this section will trigger a fresh election. In this case, the election being void ab initio, the incumbent president will continue in office until a fresh election is held, the result declared, a candidate returned and sworn in as president. The Parliamentary and Presidential Election Act does not provide the procedure for presidential elections. In this section 140, it is left open. What is important to note in respect of a fresh presidential election under Section 54 and Section 114 is that there is no return of a candidate. The incumbent president therefore continues in office until a fresh presidential election is held and the candidate is returned and sworn in. On the other hand, under Section 100 of the Parliamentary and Presidential Elections Act, there would have been an election, and this comes under Section 96, 98, 99 of the Parliamentary and Presidential Act. There would have been an election, the results would have been declared, and the candidate returned. The election has been concluded, but the challenge has been raised. What is the challenge in Section 100 is not the election, but the return of the candidate as a member of the National Assembly or as president, as the case may be. Where the challenge to the return of the candidate is successful, Section 3B, subsection 4 and 5 will apply, and under Section 3B, once the declaration is made, the Registrar of the High Court shall inform the Commission, and then the Commission shall publish a notice in the Gazette stating the effect of the order of the High Court. And subsection 4, pursuant to that declaration, a fresh election will be held. And subsection 5 says the declaration by the High Court under subsection 3B shall not invalidate anything done by the President before that declaration. The duty of the court under this section is to declare and due return of the candidate unnormal. The Registrar of the High Court will then notify the Electoral Commission, who should notify of the effect of the declaration. The Commission is required to give notice that there is a vacancy for the seat of the National Assembly or the office of the President, as the case may be, and that there shall be a fresh election. What happens thereafter depends on which office the declaration relates. In case of undue return of a member of the National Assembly, the Parliamentary and Presidential Election Act and the Constitution are clear on what will happen. The Registrar of the High Court will notify the Commission of the decision of the High Court. The Commission will then gazette the decision of the High Court and the effect thereof, that there is a vacancy, that there will be a fresh election. Thereafter, the Speaker of the National Assembly will gazette the vacancy and the cause thereof under Section 44 of the Parliamentary and Presidential Act, which states, I quote, a vacancy in the membership of the National Assembly, which exists that by the dissolution of Parliament, shall be published by the Speaker by notice in the Gazette stating the cause of the vacancy. Further, under Section 32, subsection 2 of the Parliamentary and Presidential Act, which provides, and I quote, when a member of the National Assembly dies or resigns, or the Speaker gives notice under the relevant provisions of the Constitution that a seat of the member of the National Assembly has become vacant, a by-election shall be held. It is important to mention that the holding of a by-election can be deferred if the member affected by the declaration files and prosecutes an appeal. This is in accordance with Section 63, subsection 3 of the Constitution, and Sections 33 and 44 of the Parliamentary and Presidential Election Act. Section 63, subsection 2 provides that, and I quote, the Speaker of the National Assembly shall give notice in the Gazette in the event that the seat of any member of the Assembly shall become vacant under this section, provided B, any by-election to fill a vacancy that occurs shall be held within 60 days after the seat of the member of National Assembly becomes vacant, or if, in the opinion of the Speaker, the circumstances do not so admit, as expeditiously as possible after the expiry of that period. Close quote. What comes out clearly is that a by-election to fill a vacancy in the National Assembly must be held within 60 days. That is, there must be an election, results, and return declared. This is determined by the Constitution. In the event of an appeal or any other intervening cause, the Speaker will determine as expeditiously as possible the date of the by-election. The Constitution, therefore, vests authority to determine the date of the by-election in the Speaker and not the Electoral Commission. There is no procedure for a presidential election, as I said earlier, after the due return. If, after the Registrar has notified the Commissioner of the declaration of the High Court, the Commissioner puts a notice in the Gazette of the vacancy of the President and that there will be a presidential election. It is crucial to bear in mind, however, that when the court declares that there was undue return or election of the president, the candidate retained and his running mate cease to have the right to occupy the office of president, and it therefore becomes incumbent for the state to have a fresh presidential election to fill the vacancy in the office of the president. As I said earlier, what transpires thereafter, in accordance with the process of democratic transition of the government, will be determined by the choice of the president-elect. First and foremost is that after the results of the polls are published, it is open to the contenders to challenge the return of the winning candidate. Should there be no such challenge, the poll is determined and unassailable. However, where there is a challenge to the return of the president, it is open to the president-elect to choose to be sworn in immediately or to wait for 30 days before it becomes mandatory under the Constitution to swear him in accordance with Section 83, Section 81, subsection 3. Where the president-elect elects to wait for 30 days before being sworn in, the presidency does not transfer. The incumbent president will continue. The advantage of this is that the complaint dispute mechanism, which is available under Section 114 of the Presidential and Parliamentary Elections Act, remain available. What is most significant is Section 114, subsection 4 of the Parliamentary and Presidential Act, which provides that, and I quote, "The court shall have power to direct scrutiny and recount of votes if satisfied during proceedings of an election petition that such scrutiny and recount are desirable." This is an effective and less expensive mode of determining electoral disputes, particularly if the dispute is quantitative. A recount procedure is not available as a remedy once the candidate is returned in office. The only result once the candidate has been returned in office is to have fresh elections. The second option is where the president-elect elects to swear in, whether earlier in compliance with or later in compliance with Section 81, subsection 3 of the Constitution. He or she will have succeeded into the office of the president. Where the president-elect is being re-elected from the previous government, he or she hands over to or takes over office from himself or herself. In any case, there will have been succession to the office. The president is entitled to hold office, notwithstanding the challenge, until and unless the High Court declares undue return. The return of the president after the challenge under Section 100 of the Parliamentary and Presidential Elections Act is therefore voidable. It becomes void only after a declaration by the High Court of undue election, and this will create a vacancy in the office of the president. The divergence comes in as my colleagues would have a view that the parliamentary undue declaration under Section 100 of the Parliamentary and Presidential Elections Act is void ab initio, and therefore no vacancy is created, and the presidency reverts to the one who had office before the general election, notwithstanding that he or she has been sworn in. I find that this position is not tenable. To begin with, one cannot reconcile the position that a declaration of undue election under Section 100 of the Parliamentary and Presidential Elections Act creates a vacancy in respect of a member of the National Assembly, but does not create a vacancy in the presidency. Secondly, one cannot reconcile the position that the presidency that is void ab initio is capable of executing office constitutional duties which would remain valid at law. There's even an attendant difficulty that could be perceived where the ones that held the office previously have died. It is my firm view, therefore, that the declaration of undue election of President under Section 100 makes the presidency voidable and creates a vacancy. Since the President is elected concurrently with the first Vice President, the declaration of undue return creates a vacancy in both offices. And the only recourse in such a case is Section 85 of the Constitution, which provides that if at any time both office of the President and Vice President become vacant, the Cabinet shall, from among its members, elect from among its members an acting President and acting first Vice President, who shall hold office for not more than 60 days, or where 4 years of the presidential term have expired, for the rest of the presidential term. The Cabinet that elects the acting President, acting Vice President, would have been formed before the presidency became void and survives by virtue of Section 100 subsection 5, which deems that anything done by the President before the declaration remains valid. The election by the Cabinet in such case, however, would exclude the President and the first Vice President by a operation of Section 103, subsection 3 and 104, because they would have been declared unduly elected. The nullification of the election by the court below, therefore, is not supported at law. Although there is no specific procedure for a presidential election thereafter, it is clear that the matter will go before the Cabinet in accordance with Section 85 of the Constitution. After the Cabinet elects the acting President, the acting first Vice President, the nation once again will have a parliament in accordance with Section 49 subsection 1 of the Constitution, where parliament will consist of the acting President as head of state and the National Assembly as those that have from the parliament. The President and the National Assembly will be aware that the acting President has to hand over office to an elected President within 60 days, who will decide the date of the election. It could not have been the intention of the framers of our Constitution to relegate authority to decide matters of presidential election to the Electoral Commission, which does not even have authority to decide the date of a by-election. It is my judgment, in my view, therefore, that the presidency does not revert to the previous government after the President-elect succeeds office by being sworn in. I find that it was not open to the court below to extend the term of the previous government at all. Lastly, I find that the authority to determine the time frame for a fresh presidential election under Section 100 vests in Parliament and not in the Electoral Commission. One thing that I need to refer to is the term of the presidency as has been made in the directive paragraph B. The term of the presidency is from one general election to the next general election. This is decided by Section 67 of the Constitution as I've previously premised. However, tenure is provided for in Section 83 of the Constitution, which states that the President, the first Vice President, the second Vice President may serve in their respective capacities a maximum of 2 consecutive terms, but when a person is elected or appointed to fill a vacancy in the office of the President or first Vice President, the period between the election or appointment and the next general election of the President shall not be regarded as a term. In my view, there will be no need to amend the Constitution to create a full term for the President. It is clear from this Section 83, subsection 3 of the Presidency, that the presidential election or appointment between general elections creates a non-term presidency. The President who will be elected in the coming presidential election will serve a non-term presidency up to the next general election. The same thing happens to a member of Parliament who is elected in a by-election. He or she will serve for the remainder of the term of that Parliament. Other than what I have specified in this opinion, I agree with my brother justices and do concur with the majority judgment. I would not express any opinion on the rest of the issues which I defer to the final disposal of the whole court. Thank you, Chief Justice.
It remains for me to convey my gratitude to senior counsel and all counsel before us for following this matter from where it started to where it now ends before this court. Your application has been insightful and indeed a clear commitment to ensuring that our law evolves and develops. Let me, in the same message, convey my gratitude to all those that are present in the gallery and also to members of the press, not to forget our tip staff. You will have noticed in the course of our reading of the judgment that in some instances we could not, or let me put it this way, in some instances we were not express and adopted some typos as we read. I did promise at the beginning of the judgment that we will take all endeavor to make sure that the judgment is perfected in the shortest possible period. It is a judgment that all of you must have, including institutions of government. In the course of next week, we will make sure that you have a fully perfected judgment. Other than that, this is where our proceedings, stop, and therefore seek that we take an adjournment. Thank you so much.
However, wow. It's done.
How excited are you with the judgment?
I am so happy. I could dance if I had dancing legs. It is, I believe, a vindication of what justice looks like. And we're ready to follow through with what needs to happen. But this country deserves better. And I think our Supreme Court justices have just proven that. They have continued to uphold the bar that was raised by the Constitutional Court. And we believe that Malawi will set an example, not just on the African continent, but across the world, that if you seek justice, you can find it when you have justices that are people of integrity.
Same candidates, same voters. What do you make of that?
I don't know yet. I will have to ask what they make of that. But I'm just happy I'm a candidate. Ine tunathokoza kwa basi ndine wokonja mtundu wonse oti chimwemwe chachitudzaza matsaya kumudziku anthu akondwa zedi chifukwa adaona mmene nkhani idayendera ku khoti kuno kotero kuti ena amadandaulawa kuti ampaka tipite ku khoti lomaliza tsana alibe kolowa asowa ndewero tere kupanopa ndili mchimwemwe kuti Amalawi Mulungu amva pempho lakuti chilungamo chizioneka ndipo ndikuthokoza oweruza ndikuthokozanso maloya wathu amene anaona kuti ngakhale wena anachita apilo koma apereke mfundo zakuti apilo imeneyo inali yosayenera. Lero zatsimikizikadi nkhani yafika pothera palibenso kwina kumene wina angalowe tere kutakondwa.
Would you still demand changes at MEC because of his ruling in terms of personnel at MEC?
Zimenezo kaya tsopano zaoneka poyera kuti iwo achangosayenera ndipo ngati ndi anthu opa chauta ndipo amafuna di kutsata zimene amalonjeza tere ntchito yawo iyenera kuti yathalera. It's not even just a question of demanding. If they have any sense of integrity at all, unless they surely are living in denial, what the Supreme Court has said now ought to make them put down their tools today, right here and now, and say, it's over for us.
Thank you so much.
You're welcome.
Okay, what should Malawians be expecting now? The Supreme Court of Appeal has maintained the same candidates and the same voters. We understand you are going as the running mate for Dr. Lazarus Chakwera. What should be expected from you? Do you intend to withdraw?
No. The spirit of the judgment is that those candidates who were there last year are eligible for the fresh election. So, and one can opt out because you can't really be forced to be a candidate. So, we'll continue as we presented our papers 2 days ago. Should there be need for a revisit of that position, then we'll be guided by the Commission after they too have made sense of the judgment. But it's fairly straightforward. You can't have new candidates, and those that were eligible last year are eligible now. But if anybody wanted to drop out, I think people should be free to drop out.
On the case of new voters not being allowed this time, will you also express to us the registration of underage? Now, with this arrangement, how do you react?
Well, it's very good. I mean, if you recall, a few days back I said these guys who are registering underage people are wasting both their time and money. You know, today that they have been, you know, the position has been taken, has been made that only those that voted last year, and it makes sense because those are the ones whose rights were violated. If you didn't participate in the elections last year, you can't claim that your rights were violated. But those that voted then were denied the opportunity to have the, you know, the rightful leader that they wanted. So we are very happy that, you know, the underage, you know, voters can't vote. But the only thing is that they have wasted, you know, blank cards. We should have kept those IDs for good use in future. I wished, you know, they were punished to bear that cost because it was completely unnecessary and totally ridiculous, as I said a few days back.
Obikisana omwewo chaka cha 2019 inu mukupita ndala zasidakwera tsopano chichitike ncha
mafulumira ndifunso mukana ndifunso ndikumva bwanji pano ya ndikuyankha ndinena kuti awa anthu atamenya sono 6-0 ife adabwera kuyamba kuti ayimitse mlandu adapunthidwa anakapanga apiri kuti zipa anakakanthidwanso kumeneko kubwera ku constitutional court kuja adapondedwa kuyesa kutenga injunction kuti judgment isapitirire kumenekonso adakasasantha kupita ku Supreme Court chimozimozi lero nde mapeto abwera fumbitsa pano alibe sokolowera ndiye apa akutuuza kuti amene anayima chaka chatha ndi amene ali ovomerezedwa kuti apange nawo chisankho chimene chikubwerachi. Ine ndine ovomerezedwa ndikhoza panga nawo chisankho ngati presidential candidate, koma ndilinso ovomerezedwa ndikhoza panga withdraw candidate yanga ndikupanga peya ndi Dr. Chakwera ngati meta peyira mapepa athu dzana lomweli. Ndiye zimenezo zibe vuto tipita mmene tapangira president mapepa adzana kuti chisankho chichitike mwansanga.
Nkhani ya anakulembetsa munadandaulapo pa msonkhano wanu watu wankhani sabata lomweli panopa kunena kuti atsopano savota mukumvapo
zimenezo zabwino kwambiri chifukwa poyambirira kumatenga ana ang'ono kumakalembetsa malamulo a dziko lino savomera ndikayi kungoti anthu ake wande agunda mkutu satsata malamulo. Komabe lero aonekera poyera amene akavote ndi okhawo amene anatengapo mbali chaka chatha. Enawo ma rights awo kapena kuti maufulu awo sanaphedwe munjira ina iliyonse, koma okha amene anavota ndi amene anaberedwa voti chifukwa sanaone president amenewo amamufuna. Pachifukwa ichi tili okondwera chongo khumudwisa nchonena kuti nanga siaononga ndalama ndipo ndalama zimaonongedwazo nza misonkho yathu kanza maparastato zimene amatutira makapereka ma station ali mwa mafumu m'madera mwinamu. Information yonseyo tinayo ndifakedzana lija limanena kuti mukuononga mukutaya nthawi yanu mukuononganso ndalama. Lero ndizi kuti mwaononga ndithu ndalama ndipo pa mapeto pache okavota ndi amene anavota chaka chatha. Awa malemba ana ang'ono mwapezere zina zochita ndipo zochitazo sikuvota nawo pa chisankho chikubwerachi. Zikomo kwambiri.